Yes, counsel, let's proceed.
Good morning. Jamie Vandersam representing the defendant, Joseph Canty. There are two main issues in this case. It's an OUI case. The first issue is whether the police officers improperly opined on the issue of guilt. The second issue is whether where a defendant is indicted for and actually pleads to a non-existent offense, excuse me, he may be held constructively convicted of a real offense based on signals that are allegedly out there that may have indicated to him what the offense was supposed to have been, as opposed to what it was stated to be on an indictment. On the first issue.
Do we know whether the evidence that was presented to the grand jury was sufficient to make out a claim for which the Commonwealth believed the defendant was charged?
Your Honor, I believe that I'd have to look at that again, Your Honor. I'm not.
But you're not arguing that the evidence presented to the jury or the grand jury was insufficient?
That is not the argument, and the Commonwealth did submit. I do have those grand jury minutes. I have not looked at those since they were submitted by the Commonwealth. But my argument is, well, again, back to the first question, whether the officers in this case improperly opined on the issue of guilt. I think this court has answered this in part. Commonwealth v. Jones, 2012, December. This court, in a footnote, actually said, officers can say someone, an arrestee, was drunk. And that is traceable to these cases, which are commonly cited: Suderth, 1994, and Atencio, which in turn trace back to some civil cases where this court held in the early 20th century, 19th century, that you could opine that someone was drunk. But the court said in Jones last year in December of 2012, in this footnote, that you cannot testify that somebody is under the influence as an officer.
Is it that you can't testify under the influence, or was the driving was impaired? I guess I'm trying to, are you arguing, this is my question, are you arguing that anything about under the influence, whether in connection with operating the motor vehicle or not, is not, cannot be testified to by a police officer? Or are you saying, I mean, you had here two officers, and one of them, if I'm recalling, Officer Bulmer, I think?
Yes.
Who actually linked the impairment and the driving, but the other one didn't.
That's correct, Your Honor. So there are several.
Both of them that you are pointing to as being problematic, or
so there are several different phrasings, and I'm saying that you can't say under the influence. That tracks the statutory language. Under the driving or operating a motor vehicle under the influence of intoxicating liquor, that is the statutory language. I think when you track the language under the influence, and I think the court in Jones said this, you can't do that. As for impaired, the second officer here said, I think the question from the prosecutor in each case was, did you form an opinion as to sobriety? And I think the prosecutor with that question is trying to be consistent with the case law that has said sobriety's okay, drunk's okay. But in any case, Officer Tarantino to that question said, I think he was probably impaired. Well, I do think that's improper. I do think that's clearly opinion of guilt, because impaired at what? I mean, that is shorthand for the legal standard, which is inability or incapacity or a diminished ability to drive safely because of consumption of alcohol. That's the Connolly standard. That's what the judge will instruct. That's what under the influence means. And I think impaired is just shorthand for that. It means impaired, diminished.
So what are the buzzwords, the proper buzzwords for something short of knockdown drunk and under the influence?
Well, again, the court has said, and I don't think the court should have, but I'm willing to concede this law has been around for a while. The court has said you can say drunk, but they may not want to say drunk because they may not believe it. Maybe in this case they did not.
Well, certainly could say under the influence of alcohol.
I don't think so.
Form an opinion? Yeah, I formed the opinion was under the influence of alcohol.
Which is commonly said, and in Jones the court said no, in the footnote to Jones.
Just cite Jones.
I'm sorry, I didn't. This came out, I didn't. I could submit a letter, Your Honor. This is December 2012, I think footnote 464 Mass 16. 464 Mass 16. It's one of the first 4 footnotes. But anyway, I will submit a letter. The court said no to that, but I think the question that this case, assuming that it has been decided, and I think that was certainly a good decision, I think the court should also say you can't state the legal standard in response to the question, did you form an opinion as to his sobriety? In other words, you can't say, as Officer Bullman did, I believed that his ability to drive was impaired because of consumption of alcohol. That is almost verbatim the legal standard. It's almost as if you're handing the witness the judge's instruction and saying, did he do that? Because that is exactly what the judge is saying, ultimately. That's how the judge is explaining under the influence. The question, though, Your Honor, what else besides drunk? If it's not quite drunk, perhaps not quite drunk.
Tipsy?
Sure. Sure. Some of these colloquial expressions that I think would convey to the average juror, the layperson, what the officer would mean. There are plenty of ways, though, of actually stating the facts here, and that's why I think these opinions are so unnecessary. When people hear the glassy eyes, the slurred speech, the alcohol on the breath, the unsteady on the feet, all the stuff you hear in every case, I think they get the point, and I think the jury should be made to rely on those facts. But in any case, this is nothing new, the notion that you can't opine on guilt. This often comes up in a street-level drug transaction case, for example, and the court will say, no, you can't testify, officer, that you believe that you saw a transaction. I don't see how there's any difference, any material difference between saying, is this person under the influence, or saying this person was under the influence, in my opinion, or saying this person's ability to drive was impaired, or saying that this person...
Let's get down to the specifics, because we're talking words here. We're really
Yes.
talking words. All right, Bullman says, I believed his ability to drive was diminished. And you say that's exactly the issue before the jury.
And then the prosecutor says, by what? And he says, by alcohol consumption. Yeah. So yes, I'm saying that is very close to verbatim Connolly, which set the standard. And the standard is in the model instruction as to what operating under the influence means. So I'm saying no to that.
And Tarantino says, based on what I observed, in my opinion, he was probably impaired.
Yes, and I understand it's just impaired. They're cutting off by what?
Couldn't walk a straight line, couldn't do all the things he was
this
asked
is,
to
after
do.
all, a drunk driving case. Okay. This is, after all, an OUI case. They're not asking him whether he's impaired insofar as his cooking ability or his TV watching ability or anything else is concerned. Obviously, he is that is a legal term of art. I think maybe the officers don't even realize it at this point. But impaired is not a natural way to respond when you're just asking whether somebody is affected by alcohol. That expression grew out of this context of the OUI case to mean impaired insofar as his ability to drive was diminished.
But the pragmatic consequence, if you're right, is that we have a situation in which an officer is asked the question which he was asked, which you say is appropriate, and the answer is, I think it was probably impaired. Objection, sustained. Okay, he was diminished. Objection, sustained. Okay, he was drunk. I mean, it gets a little bit silly to have this person trying to find the words which are viewed as appropriate when, to a jury, they all essentially mean about the same thing.
Your Honor, I don't think drunk is there's been a case that said as much. It might have been Connolly. Drunk is not the same as impaired. Drunk is not the same as OUI. It may very well have been the case or there may be cases where officers really don't think the person was drunk. So they won't testify to drunk. I don't think it's the same thing. Okay. I think diminished and impaired, these are legal terms that have developed in order to describe this state where someone's ability to drive a car is diminished. So I do think there's a distinction.
So is buzzed appropriate?
Lotto?
Well, I can't say that it isn't. If drunk is okay, I don't think I can say that there's anything wrong with that. Again, I think
it's the problem that you think that it's just so it's such an easy leap from one of those words impaired to driving, because of course that's what's before the jury.
Yes.
Impaired for what? I mean, it's an unspoken question, but of course that's the context in which it's being raised.
I think it's an inescapable inference that a jury will draw that when you say impaired in a drunk driving case, you're talking about impaired by what? Alcohol. You're impaired insofar as what is concerned, your ability to drive. I don't think there's a material distinction there. And I think yes, they can say, I felt that he was I just felt he looked drunk to me.
But if the jury really understands what the officer is saying, if he were to testify correctly or appropriately in your words, where's the prejudice?
Well, the prejudice is, the case that kind of establishes, the case is called Hesketh. This court's case about 30 years ago said, look, the problem with opining on guilt or actually tracking the language or actually stating your opinion on the ultimate issue is that it tends to convey to the jury a sense that their responsibility to decide that is transferred so that they can literally adopt the opinion. And, a judge will say at the end of a case, the evidence is what you heard from the lips of a witness. So the mere saying of that fact, it licensed in evidence, the putting of that opinion in evidence licenses a jury to substitute that final opinion, that ultimate conclusion as to what went on for their own. And I do think that's significant, particularly when it is a police officer who is saying it.
But was that a breaking and entering case or a fraud case? It's one thing to say for a police officer to get on the witness stand and say, in my opinion, he stole the stuff. Mm-hmm. It's another thing to say he was drunk and then maybe cross the line and say, yeah, he was operating under the influence, because a jury knows exactly what's going on in a drunk driving case anyway. Well,
the jury will ultimately be instructed that the defendant is guilty if they find he was operating under the influence, and that means driving with an impaired ability or having an impaired ability to drive as a result of alcohol consumption. I think when they hear that, and then they also hear the judge say, look, you can take those opinions that you heard from the officers, you can take them or leave them. They may think, oh, well, he stated an opinion that this person was guilty, i.e. he was under the influence, and I'll take that. I'll take that.
Yeah, we've trained, sorry, I wanted you to finish your sentence, but I didn't want you to lose my opportunity to ask you this question. I think we, if you will, train officers to testify in light of our decisions. So, for example, officers now say, consistent with a drug transaction. They don't say, that was a drug transaction. So what language would you propose, if we agreed with you, would be inappropriate? I mean, lots of words. Is intoxication okay? Had a level of intoxication, had a level of, or nothing?
Well, I think, again, appeared intoxicated, drunk, sure. Intoxication doesn't suggest impairment in the driving sense. That consistent with language, though, I think that comes out of expert testimony typically. Is that consistent with a drug transaction? What you saw? I don't really think this is material for experts. So I don't think the consistency.
Right, I'm just talking about the training aspect.
Yes.
Right?
Yes.
We can get people to not say if it's inappropriate, and we agree with you. So what is appropriate is.
Yes, and I think I do think there's a reason to, well, again, the court I think has said as much for under the influence, but saying, just tell us what you saw without applying the law to the fact. Saying impaired is applying the law to the fact. It is stating the ultimate conclusion. If I could, I don't have much time, but if just this other issue, which I do think is significant. The indictment in this case on indictment number 1, count number 1 said operating under the influence while operating after suspension. It's not.
And cites the statute.
It cites Chapter 90, Section 23. It does.
Which requires the element that the prior suspension be for operating
because of OUI. So if we call this, this statute has OUI while OAS for OUI. And it has OAS for OUI. But it doesn't have OUI while OAS. I'm sorry, but.
So it's missing an element.
Pardon?
It's missing
an element. And there are cases, there's this case that has been cited by the Commonwealth. There are a couple of cases, Fernandez and Green, for example, where this court has said, you don't have to include every element. But I don't think this is analogous. Here, the court said this, for example, in Commonwealth v. Green, there was an indecent assault and battery case. And the court said, look, you don't have to say there's lack of consent. You don't have to cover that element on the face of the indictment because that's implied. I mean, that's part of assault and battery. That's encompassed by it. You can use the larger label. That's not what happened here. There's nothing about OUI while OAS that implies OAS for OUI. It's not.
If the grand jury heard sufficient information on which to issue a correct indictment, a proper indictment. Could the Commonwealth have moved to amend its indictment to make a correct allegation?
I believe so, Your Honor. I believe so. I don't see why not. I think this is a major principle here. It is Article 12, fully, plainly, substantially. All of these words that the charge against you, it must be full, substantial, plain. There was nothing plain here. The prosecutor the Commonwealth will get up and say, look, there were all of these hints. Well, you deserve more than hints as a criminal defendant when it comes to the charge that is brought against you. And I would emphasize it wasn't just the indictment here. It was also the actual plea. They got it wrong throughout, and I don't think it's too much to ask of the Commonwealth to actually get its charges right.
The plea might have, I take it your argument would be that, well, you wouldn't concede this, but even if the plea would have cured the problem with the indictment, it didn't in this case. That's your point.
That is my point. And I think the larger and very important point is that the indictment can't simply be can't be finished or changed or constructively changed by later implication or inference. There's a case saying as much from the appeals court as well, which I've cited.
All right, sir. Thank you.
Thank you.
Good morning. Ellen Lazar-Moore for the Commonwealth. This court should affirm the defendant's conviction of operating under the influence of alcohol because the trial judge properly exercised her discretion to admit opinion testimony as to the defendant's sobriety. For more than a century, it has been the rule that a witness may offer opinion testimony as to another's sobriety or lack of it.
But that's,
and this rule,
of course, yes, accepting that, but the argument is that isn't what these officers did.
yes, that is what the argument is, but I would disagree. I think the appeals court has recognized in a number of cases, which I cite in my brief, that there are a lot of different ways that an officer can phrase his or her opinion as to the defendant's sobriety, and maybe they're intoxicated, maybe it's drunk, maybe it's under the influence, maybe ability was diminished, but really it's all semantics, and it all comes down to an opinion about sobriety, which the court has recognized is appropriate, and there is no reason why an officer should be precluded from giving that testimony, whereas another type of witness would be able to give it.
But he wouldn't.
Particularly-
Another type of witness wouldn't be able to get up on the witness stand and say, I think that that this person was operating his motor vehicle while under the influence of alcohol. He would only be able to say he was not sober. Or
I
he
don't
could
see
describe
why
the-
another type of witness would not be able to say that.
But
If there was
don't
a
we have a
person,
rule that says that you, and the only exception I think that we've recognized so far is the insanity defense. But don't we have a rule that says that a witness cannot express an opinion that goes to the ultimate issue in the case?
yes, and that is the rule that
That's
the
what happened here.
defendant claims was being violated here. But what I'm saying is that if this was another type of lay witness who, let's say, was driving behind the defendant and following him for 10 minutes, and then saw him driving erratically, the defendant pulled over, this other lay witness pulled over, got out of the car, made all the same observations that this police officer made, that witness would be permitted to give that same testimony, and that there's no reason why an officer should not be able to give it, particularly where the cases have recognized that very often it's an officer who has the opportunity to make the most observations of a defendant, have the most contact with a defendant, and that is valuable evidence that should be placed before the fact finder. And the cases should not rise or fall upon the particular phrasing or the semantics chosen by the officer, which would become very artificial, that you can say, well, he's drunk or intoxicated, but you can't say under the influence.
Are you saying that a lay witness would be able to say that the defendant's ability to drive was diminished by alcohol? That a lay witness would be able to say that the defendant was under the influence of alcohol, or that a lay witness could say that he was impaired? You're saying a lay witness could say all of these things?
If the foundation is laid that witness would have
But
the
lay witnesses
ability.
aren't supposed to give opinions.
But this court has said that a lay witness can comment as to sobriety. And I'm saying that the appeals court cases have recognized that all of these different phrases are another way of giving that opinion. That intoxication or lack of intoxication, sobriety or lack of sobriety is something that most adults can recognize. And that's why in this particular limited area, even lay witnesses can give that opinion, whereas in other areas, a lay witness cannot give an opinion.
But the opinion is only as to sobriety. It ends there.
It doesn't go to whether they have a capacity to drive.
Yes, and I'm saying that in the appeals court cases that I cite, there's recognition that it's really just a choice of phrasing and that it all comes down to
Isn't there one
an
case
opinion as to
fairly recent
sobriety.
that says, of course, it would be a mistake, it would be an error for this to happen in the appeals court?
Yeah, there are cases on both sides. There's actually a split of authority on that, and I cite them in my
No, you
brief.
do, but
Yes.
so it's not that the appeals court is speaking with one voice here.
No, and I recognize that these are mostly unpublished cases, and so therefore it's not the entire court reviewing, but that there is a recognition that the cases should not rise and fall upon semantics and the particular choice of phrasing when really the meaning of the words is always the same, and the jury would recognize that.
But, well,
Well, if we don't agree with you,
Yes.
is there prejudice here?
No.
Why not?
And because first, there was very, very strong evidence that the defendant was intoxicated or under the influence, or however it's phrased. The officers did not simply stand up and testify to their opinions. They gave all the reasons why they had formed that opinion. And in particular, Officer Bullman, who had more contact with the defendant, testified to the defendant's erratic driving, the odor of alcohol coming from him, his admission that he had been drinking, his inability to put his truck into park, his inability to do the field sobriety test, his difficulty getting his license out of his wallet, and then after he was arrested, there was a half-empty bottle of liquor found in the truck. In addition to that, the judge repeatedly and correctly instructed the jury about the Commonwealth's burden to prove every element, that the jury would determine the credibility of witnesses, would find the facts, and in particular, she highlighted the officer's testimony and said that their testimony should be treated as the testimony of any other witness, as in that the jury could assess whether to credit all or some or none. And she particularly highlighted the testimony as to an opinion on sobriety. And she said, you can choose to accept that or reject it, but in the end, it is your duty to determine whether you believe the defendant was under the influence. So given these instructions and the strength of the evidence, if the court were to find that there was error, that the testimony had stepped over the line here, reversal is not required.
Do we have other examples of lay opinions apart from sobriety? Is that unique in our law, that we allow a lay witness without particular expertise to give that opinion and not any other?
it's the assumption that there is general expertise on sobriety.
Yes, at the moment, I can't think of any other area, but yes, I believe that is the thinking. that-
Speed?
Speed is correct. I think that's also an area. Doesn't require any specialized knowledge or scientific or technical expertise at all, right?
That would make sense. I'm not directly aware of cases saying that, but I believe that that is the thinking, that this is an area where the average, particularly the average adult, would recognize the signs of sobriety or lack of sobriety and could give that opinion.
And does that then affect our review in that jurors would not be unduly swayed by a lay opinion because they'd recognize that they're in about the same position as the witness to be able to give that conclusion?
I think it should affect your review in the sense that when the officer testifies to all the signs of intoxication and why he or she formed that opinion, that the average juror would understand that those signs show or signals of intoxication, even without the opinion testimony, as opposed to something that requires more of an expertise where maybe the jury wouldn't naturally understand that these things are signs or symptoms of whatever the ultimate conclusion is. The Commonwealth would also ask the court to affirm the order denying the defendant's motion to vacate his conviction. First and foremost, because the defendant waived any challenge to the adequacy of this indictment by pleading guilty.
Yes, but the plea itself doesn't, I mean, as I read the colloquy, it doesn't really ever make clear that this is operating after suspension by reason of OUI.
I believe it does, Your Honor. I think the most important sign that the defendant knew, was aware what he was pleading guilty to, was knowingly pleading to that crime of OUI while operating after an OUI suspension, is in that the defendant and his lawyer both affirmed on the record that the attorney had explained all the elements of the crime to the defendant. There's no question that the attorney was aware of what the crime was and what its elements were. I provided to the court below, and it's in the record before you, materials that had been filed by the defense attorney, and in particular in the record at pages 46 and 47, in the recommendations for sentencing, the defense attorney calls count 1 OUI while OAS for OUI. So signaling that he understands that it was a suspension for a prior OUI. And I would note that this form was signed not only by the defense attorney, but personally by the defendant himself. There had also been a pretrial motion to sever in which defense counsel notes that all of the charges arose from a single event in which it is alleged that the defendant was operating after an OUI suspension. And that is at page 50 of the record. So when the defense attorney represents to the court, yes, I explained all the elements of the crime to the defendant, and the defendant represents to the court, yes, my attorney explained all the elements of the crime to me, we know clearly that counsel understood the elements and that this was the crime with which the defendant was charged. As I said earlier, first and foremost, most importantly, the defendant has waived any challenge to the adequacy of this indictment by pleading guilty to it. And I would point the court to a statute, which I apologize I did not cite in my brief, but Chapter 277, Section 47A, which provides that any objection to the indictment must be raised prior to trial or else it is waived.
So if an indictment is based on evidence of operating negligently, and the defendant pleads guilty to that indictment, and yet the colloquy tracks the language of drunk driving, there's a waiver?
What the defendant is claiming here, in my opinion, is essentially a complaint that the indictment didn't put him on adequate notice because it did not contain every element of the crime, that it was missing an element. I believe that he can waive a claim that he was not put on notice of one of the elements of the crime, and that he did so here by choosing to plead guilty. In my opinion, as I said, there's no question that he was put on notice, and counsel's statements on the record and the defendant's statements on the record show that he was put on notice. But in my opinion, he could waive that claim and did so by pleading guilty. In addition to the fact that I cite cases to the effect that you need not state every element of the crime in the indictment. In addition, I would note that this is a 6-count indictment. This was count 1 out of 6, all 6 counts arising from a single set of events, and that other counts in the indictment did include that allegation that the suspension had been based on a prior OUI. It was also, the statute was cited in the caption of the indictment, and at least 5 times during the course of the plea hearing, it was said by either the clerk or the judge that this was a suspension for a prior OUI. So it was not that this element was completely omitted from the plea hearing. The name of the crime is very long, operating under the influence while operating after suspension for operating under the influence. So I believe throughout the plea hearing, you can see, if you read the whole thing, that everyone was using different shorthands to refer to the crime, which is why, as I said, in the recommendations for sentencing, defense counsel calls it OUI while OAS for OUI. Everyone was sort of coming up with their own shorthand expression for the crime.
And that's what the statute, that's specifically what the statute prohibited
Yes, exactly. And the statute is cited
in the indictment.
on the indictment. And I think if you read the 6-count indictment as a whole and the plea colloquy as a whole and the other record materials, that it's clear that the defendant was charged with this particular crime and knowingly pled guilty to this particular crime.
Well, he was also, am I remembering correctly, he was charged with just operating after suspension for OUI?
Yes, that was count 2.
Right. So in count 2, did the suspension for, was it clear
Yes.
that the suspension and it was the same suspension we were talking about?
Yes, so this was, as I said, one set of events, 6 indictments, 4 of which included the operating after suspension. So there was OUI while operating after suspension for OUI. Then count 2 was just operating after suspension for OUI, the only distinction being whether he was currently OUI. And in fact, that was one of the questions that the judge asked during the plea hearing. And the prosecutor made clear that the only difference between counts 1 and 2 was whether he was currently OUI. And then count 3 was, I think, just operating after suspension, and then count 4 was operating after suspension second or subsequent. So there were 4 different variations on that.
Do we have the grand jury minutes?
You do, and it's at pages 20 to 21 where the grand jury heard evidence that the suspension had been the result of a prior OUI. So the Commonwealth would ask the court to affirm both the defendant's conviction and the denial of his motion to vacate conviction.
Thank you.
Thank you.